thematic area is our contention that the Political Parties Amendment Bill 2021 went through adequate public participation. Very quickly, my lord and my ladies, on the first thematic area, the principal in Anarita Karimi Njeru, and those submissions will be detailed at paragraphs 10 to 27 of our written submissions. We submit that any alleged violations of the Constitution must always be pleaded with reasonable precision. And the reason for that is that that is the only way you give the other party a reasonable opportunity to respond to your allegations. And we have cited the Anarita Karimi Njeru case, which is case number 1 on our case digest, and the relevant part is at page 2 of our bundle of authorities. And that particular decision, Lord and my ladies, has been reiterated in the Mumo Matemu case, Mumo Matemu versus Trusted Society of Human Rights Alliance and 5 others, case number 2 on our case digest, and also page 19 of our bundle of authorities. Allow me, my lord and my ladies, to very briefly highlight some of the violations that we perceive to be flowing from a violation of the principle in Anarita Karimi Njeru. The 2nd to 5th petitioners, for instance, allege that the definition of a political party in the Amended Political Parties Act contradicts the one in the Elections Act. And they state that in paragraph 18 of the 2nd to 5th petitioner's petition. They allege that this contradiction, this alleged contradiction, offends the requirement of legal certainty. Petitioners further allege that there is a contradiction between Section 27 of the Elections Act, which requires party nomination rules to be submitted to the IBC at least 6 months before the date of a general election, and Section 10, which allows the formation of coalition political parties up to 120 days to the date of the general election. And to the petitioners, this means in part that the timelines in Section 27 of the Elections Act may not apply to coalition political parties. In response to this, Lord and my ladies, we submit that there is no such contradiction. And And even if there was a contradiction, my lord and my ladies, mere contradictions between statutes cannot be a basis for unconstitutionality. We all know, my lord and my ladies, that we have very well developed rules and canons of statutory interpretation to resolve any possible contradictions between statutes. And on this, we rely on the case of Martin Wanderi and 19 others, which is case number 8 on our case digest, where the court found, and I quote, where provisions of one act of parliament are inconsistent or repugnant to the provisions of an earlier act, the later act abrogates the inconsistency in the earlier act. End of quote. And in another case, MJ versus NK and another, number 9 on our case digest, the court ruled that specific statutes prevail over general statutes in the event of a conflict between them. So, my lord and my ladies, where there are conflicts, where there may be contradictions, and we submit that in this case there are none, we have sufficient interpretive canons and guidelines established by our courts to resolve those conflicts and contradictions. That cannot be a basis for unconstitutionality. The second example that I wish to highlight is the second to fifth petitioner's claim that defining a political party to include a coalition political party renders the amended political parties unconstitutionally vague and unenforceable. And they make this argument because, according to them, the definition tries to mean two different things at once. That is, a political party that is an association of citizens brought together by a shared ideology, and on the other hand, a political party that is formed by political parties to pursue a common goal. And they make that argument in paragraphs 25 to 26 of the second to fifth petitioner's petition. We disagree with this position for three main reasons. Number one, the petitioner's argument on this point does not disclose any unconstitutionality. Number two, we disagree that a legal definition cannot consist of two or more components. submit that it is enough that the definition is clear and that the various components are demarcated with precision. Number 3, we disagree with the petitioner's position that political parties cannot come together on account of ideology as their common goal. On the third point, my Lord, we are disagreeing with the petitioners when they allege that political parties, as corporates, cannot come together on account of ideology, and that ideology being their common goal. We submit that that position is erroneous and without any logical or legal basis. We further submit that political parties can come together to form a coalition party that is based on a shared ideology. The third example that I would like to give of what we perceive to be deficient in the petitioner's case relates to the petitioner's allegation that there is no fundamental distinction between a coalition political party and a coalition because the processes of forming a coalition and a coalition political party are the same. And for them, that process entails the creation of a coalition agreement and depositing the same with the Registrar of Political Parties. And they make that submission at paragraph 26 of the second to fifth petitioner's petition. In response to this, my Lord and my ladies, we submit that whereas we agree that the processes of forming a coalition and a coalition political party are largely the same, they are not entirely the same. In the case of a coalition political party, there must be a clear indication contained in the coalition agreement that those subscribing to that coalition agreement intend to form a political party, a coalition political party. In the case of just a coalition, that indication is not there. That expression of intent is not there. And so to that extent, there is then a difference between the process of creating a coalition and that of creating a coalition political party. The fourth example I wish to give is that the petitioners allege that the concept of a coalition political party is partly unconstitutional because it's unprecedented. But it has never happened anywhere else, in any other jurisdiction. First point I wish to make in relation to this is that a statutory provision cannot be unconstitutional simply because it is internationally unprecedented. We have our unique constitution, and as long as there is compliance with our constitution and our laws, the question of international precedent, with the greatest respect to the petitioners, is irrelevant. Be that as it may, Lord and my ladies, the concept of a coalition political party is actually not unprecedented in our own legal system. And there is precedent in our own statute books. My lords, I wish to, my ladies, I wish to refer you to Section 2 of the now repealed Political Parties Act 2007, which we have included in our bundle of authorities. That section recognized corporate membership to political parties. And in fact, the corporate members of political parties were defined, and I quote, other registered political parties. So, my lord, my ladies, as early as 2007, we already had this concept of coalition political party. It is therefore not correct, it's not right, it's not true that this concept is unprecedented. The fifth example that I wish to highlight relates to the petitioner's allegation that this concept does not address Parliament's intended objectives. And they make this allegation at paragraphs 46 to 51 of the second to fifth petitioner's submissions. Paragraphs 46 to 51 of the second to fifth petitioner's submissions. And in response to this, we humbly submit that whereas the petitioners may have their own preferences as to what the law should say, and whereas they may also have their own views as to the necessity of a law, nevertheless, those preferences and views cannot be the basis for unconstitutionality. A law cannot be unconstitutional just because the petitioners would have wished that law to say something different from what it says. And a law cannot be unconstitutional simply because the petitioners are of the view that that law does not meet its intended objectives. And on this particular submission, we rely on two decisions. Mark Obuya, Tom Gitogo, and Thomas Mara, and Kenya Insurers, and 5 others versus Commission of Domestic Taxes. They are to be found at number 3 and 4 of our case digests and pages 41, 57, and 58 of our bundle of authorities. And very briefly, just to summarize what these cases are all about, it was held in those cases that a court cannot be called upon to question the wisdom of legislation or its policy objects, or to interfere, in fact, with a statute merely because the legislature could have adopted a better or different statutory provisions. Lord, my ladies, allow me now to go to the second thematic area, and this is on the question of substantive unconstitutionality. Start with the question of the concept of a coalition political party and registration requirements. And our submission on this is contained at paragraphs 28 to 40 of our written submissions. The first to fifth petitioners dispute the constitutionality of the concept of a coalition political party. The first to fifth petitioners, they dispute the constitutionality of the concept of a coalition political party. In other words, they say that a coalition political party is a concept that is unconstitutional. And in support of that allegation, the petitioners allege that coalition political parties are a threat to multi-party democracy. And they are a threat because, according to the petitioners, these coalition political parties can merge to form super coalition political parties and lead to a one-party state. And they say that in paragraphs 37 to 45 of the second to fifth petitioner submissions. In response to this, we submit that this is an allegation that is completely speculative and logically deficient. We submit that multi-party democracy is not necessarily assured by the proliferation of political parties. And on this, we note that the foremost democracies in the world, in fact, have 2 or 3 major political parties. United States of America and the United Kingdom. second response to this allegation that this concept is a threat to democracy is that the Amended Political Parties Act does not compel parties to join coalition political parties. It's a voluntary process. It's a democratic process. Membership is voluntary. And that membership is based on the democratic consent of the members of the relevant party. Thirdly, and contrary to the petitioner's hypothesis, political parties will actually assure multi-party democracy because the constituent parties are able to benefit from cooperation. And they do this without losing their independent identity. I think there's a misconception that once these political parties get into a coalition arrangement, they then lose their identities. They don't. The relationship between the corporate members of a coalition party and the coalition party is governed by the coalition agreement. It's just like companies forming an umbrella company, what we call a holding company. So the holding company exists, but the other companies also exist. How many minutes have I done? I've done 30. I have another 30 because we agreed with the other respondents that they give us their 30 minutes. A misunderstanding of the import of Article 260 of the Constitution. The petitioners seem to be alleging that Article 260 provides a definition, in fact, a closed definition of the term political party. Suggests otherwise. Article 260 merely provides a broad description of what a political party is. And it's our submission that that broad description the only requirement is that such formations meet the prescribed elements as outlined in Part 3 of Chapter 7 of the Constitution. And those elements are that a coalition political party is exempted from the requirements of registration in Section 5 and 6 of the Political Parties Act, and to that extent, a situation of discrimination is then brought forth. A submission on this is paragraphs 48, 49 of the first petitioner's petition. Our response to this is that the exemption of coalition political parties from the registration requirements in sections 5 and 6 of the Amended Act is absolutely justified and necessary. And the reason for that position is that a coalition political party is an amalgamation of political parties that have already undergone the registration processes. It would therefore be unnecessary, in fact superfluous, to subject a coalition political party to the same processes. The next issue I want to deal with relates to the question of indirect party nominations, paragraphs 41 to 46 of our submissions. Petitioners attempt to impeach the introduction of the concept of indirect party nominations. And the reason for that is they claim this mode of nominations does not guarantee democracy. According to the petitioners, they say there is a possibility that the delegates would select candidates for election in this type of nomination may not be chosen democratically. We submit that these apprehensions are speculative. Further submit that the manner in which a political party chooses its candidates for election is normally based on the party's constitution and its nomination rules. And these instruments, my lord and my ladies, would derive their democratic legitimacy from the members of the party. And in any case, if you look at section 3(1)(a) of the Political Parties Act, that section binds a political party to promote inclusiveness, democracy, and participation of the people in the nomination of candidates for elections. So there is a sufficient legal framework. Concluding on these points, Lord and my ladies, it has been held over and over again that the function of this court is not to determine speculative and academic questions. And on this we rely on two authorities, John Aaron Mwau and the three others, case number 5 on our case digest, and National Conservative Forum versus Attorney General, case number 6 in our digest. And if you allow me, my lord and my ladies, very quickly to quote from the National Conservative Forum case. It is generally accepted in this and other jurisdictions that the court will not engage in determination of a matter for academic reasons. There must be a real controversy or dispute before it in order for it to exercise jurisdiction. So what the petitioners have brought before you on this question of nominations are issues based on speculation and conjecture. Issues that are not ripe for determination by this court. Let me go very quickly to the question of audit of political parties' accounts, which has been raised at paragraphs 43 to 46 of the second to fifth petitioner's petition. The concern of the petitioners is that the repeal of Section 31(3) of the Political Parties Act to remove the obligation on the Auditor General to audit the accounts of political parties is unconstitutional. By way of background, my lord and my ladies, this repealed provision required the Auditor General to audit the accounts of all political parties. All political parties. On the other hand, Article 2294F, sorry. On the other hand, Article 2294F of the Constitution, on the other hand, requires the Auditor General to audit the accounts of political parties funded from public funds. So you can see there was an inconsistency between the Constitution, Article 229, and the repealed section that required that the Auditor General audits the funds of all political parties. So what does the amendment, the repeal, then mean? It means that the Auditor General will now audit the accounts of political parties that receive public funds. And that will be in line with Article 229 of the Constitution. Secondly, the Auditor General will not audit the accounts of political parties that do not receive public funds, except when requested by the Registrar of Political Parties pursuant to Section 31(4) of the Political Parties Act. So there is compliance with the Constitution, but in addition, in the public interest, the Registrar of Political Parties can request the Auditor General to audit any other political party. The other issue that I would like to deal with very quickly relates to dispute resolution. We deal with that extensively at paragraphs 63 to 70 of our submissions. On this, the petitioners make two claims. They claim that Section 43 of the Amended Political Parties Act exempts coalition political parties from the jurisdiction of the coalition agreement in the first instance to have an internal dispute resolution mechanism. The second claim that the petitioners make is that limiting appeals from the tribunal to the Court of Appeal violates a person's right to appeal to the highest court in the land. We submit that this claim is without merit, and on this we rely on the case of Wilson Ongere Ochola versus ODM and 3 others. It's number 16 on our case digest, pages 258 to 259 of our bundle of authorities. My Lord, finally, the question of the role of the Registrar of Political Parties vis-a-vis the IEBC. The first petitioner alleges that Section 34 of the Amended Act our submission on this is that the Political Parties Act was enacted to give effect to Article 92 of the Constitution. Lord, my ladies, that is the article that provides that legislation shall be enacted to provide for, among other things, the regulation of political parties and registration and supervision of political parties. So it's a constitutional dictate. We further submit that Section 34 of the Amended Act is not in fact concerned with the general regulation of political parties and political party nominations, but with the regulation insofar as the same is necessary to ensure compliance with the Political Parties Act. It's our submission, my Lord and my ladies, that the functions of the registrar of political parties are constitutionally complementary and not in contradiction with the mandate of IEBC. Both the function of the Registrar of Political Parties and the functions of IEBC flow from the Constitution, and a proper reading of the Constitution will make it very clear that those functions are complementary and not contradictory. Finally, on the question of public participation, the first to fifth petitioners allege that the timelines that were provided for public participation by Parliament were inadequate. We submit that that inadequacy has not been demonstrated. Furthermore, Lord and my ladies, we submit that the petitioners seem to ignore completely the fact that there was very extensive public participation on this bill before it was submitted to Parliament. Learned friends have attempted to make a distinction between public participation before the bill was presented to Parliament and the public participation that happened in Parliament. We respectively submit that that distinction is without merit and has no basis in the law. The purpose of public participation is to give the public the opportunity to comment and to make their contribution in as far as the proposed law is concerned. And we cannot truncate the public. It's one public. It's a continuous process. It cannot be argued that Parliament deals with one type of public and at the period preceding Parliament deals with another type of public. It's the same public. And so it's important that in looking at this particular issue, the very extensive public participation that took place before this bill was presented to Parliament must be considered. My Lords, that brings me to the end of my highlighting. As I said, we have filed very extensive submissions, and I'll plead with my Lord, my ladies, to take time to look at those submissions.
Our not just learned but good friends for the petitioners earlier on this afternoon, there were certain issues that they submitted on extensively, which, with tremendous respect, do not arise from their pleadings. I just wish to point out those submissions or those issues. The first was the issue about the proximity in time of the amendments to the or in which the impugned amendments were made to the election. The second was the submission about the proposal that they are of retrospective effect. I submit that to allow those submissions to remain on record and to then consider them and determine them, as you have been invited to do by the petitioners, would amount to an ambush. An ambush of a kind that this court is constitutionally enjoined to ensure that does not happen in proceedings that are conducted regularly, that are conducted before courts of law in this republic. The second issue I wish to respond to directly is an issue that was alluded to by the learned Solicitor General of the Republic of Kenya in his response in chief, is that then the following will not be possible. If the other doesn't happen, then the following is not possible. We wish to respond to that by saying that this court has the jurisdiction and it retains the ability and because those situations in the petition that has been urged or in the consolidated petition making pronunciations in respect of those hypothetical situations. There is the submission that was made about, there were several submissions that were made about the manner in which coalition parties are regulated, or perhaps to borrow directly from the submissions of my learned colleagues, how coalition parties are